Supreme Court.
Good morning, everybody. Thank you very much. Please be seated.
Please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re 2078 Jersey Street CU Reconsideration Denial, case number 23 AP 247. Representing the appellant, the town of Ferrisburg, is Kevin L. Kite. Representing the appellee, 2078 Jersey Street LLC, is Kevin E. Brown, seated at council table with Attorney Brown is Will Basilio.
Okay, thank you. Counsel?
Good morning. Thank you, Your Honors.
Good morning.
And report. My name is Kevin Kite, and I'm representing the town of Ferrisburg in this matter, which is the appellant.
Thank you.
This case involves, calls upon the court to figure out if, when, and how a reconsideration request to a municipal panel will toll the appeal deadline that is imposed under Rule 5B1.
So I'm just going to start out
Sure.
quickly, and I apologize for that, but this is an issue that's never been decided by this court.
No, it is not, Your Honor.
It's something that's come up in cases at the trial court level.
Yes.
Clearly, but not, has never reached the Supreme Court.
It has never reached the Supreme Court. The Supreme Court has spoken indirectly to the issue regarding the application of Rule 4 of the in Ray Hopkins' compliance certificate. The court discussed that rule in a footnote and indicated that there was no indication that the rule would apply to a panel, and that rule, the language in the rules, only seemed to contemplate action by the court. So if you were discussing some sort of action under Rule 4 that might somehow toll the appeal period, you would expect to see some action by the environmental court and not by a panel. So that's the closest I think the court has come to discussing this issue that's presented here.
But the environmental court itself has decided the question in a number of different cases, right?
Beginning in, most clearly, in Ray Janice C. Dunn, that was back in 1999, the environmental court was very clear about what had to happen. The panel was supposed to indicate to all the parties that it would, in fact, reconsider and then set a hearing and let everyone know that that was what was going to happen prior to the expiration of the appeal period. And if that didn't happen, then the notice of the appeal would be untimely, jurisdiction would be lost.
So no tolling? Is that what you're saying?
No tolling directly. There's tolling if the panel says to the requester, we will take up your reconsideration request. We're not going to do it right now, but we will take it up. And
Within 30 days? Within the 30 days.
The communication has to be within 30 days. The hearing doesn't need to be within 30 days. The notice to the parties that this is going to happen has to occur within 30 days, under Dunn.
So from the practitioner's point of view, I'm trying to get an understanding of where people's heads are on this issue. Has it been has it been consistently applied at the trial court level in the way in which you're describing it?
It was consistently applied through roughly 2010, when Judge Wright left the environmental court bench. It has been applied basically the same way coming forward until very recently. And it appears—
You're talking about Judge Durkin's decisions now?
Yes.
Uh-huh.
And it appears that the original rationale and reasoning for which the rule was imposed back in 1999 has been forgotten, frankly. And it's the town's position that it doesn't make sense to allow a unilateral request for reconsideration to toll the appeal period.
Would it make a difference if all the parties were served with the request to reconsider?
I don't think so, because it's the panel's decision informed to the parties, hey, everybody rest easy, you don't have to worry about your appeal because we're going to consider this question. We're going to take up the reconsideration request. And at that point, everyone is relying on the panel to take some time, have some further consideration, and wait. That didn't happen in this case. There was no communication between the panel or the appellant in the 5 days between the date the request was mailed and the appeal period expired.
Why should it matter when the panel says we're going to consider the reconsideration, whether it's done on day 10 or on day 35? What difference does it make?
Because the finality provisions in 4472, and the way this court has interpreted those finality provisions, is that in appeals from municipal panels, the deadline is firm. 30 days, file your notice of appeal with the e-court. If you haven't done that, you're out of time. The e-court no longer has jurisdiction. Doesn't matter whether it was a day late, doesn't matter whether you didn't understand the rules, doesn't matter whether you thought you were supposed to use the mailing date. None of those reasons justify extending the appeal period beyond the 30 days that's required by the rule in the face of 4472, and the way this court has interpreted that.
Right. But the filing of the appeal will then divest the local board of
That is true.
jurisdiction to hear it, unless the appellate court agrees to send it back.
That is true.
So we run into problems, do we not?
I don't think so, because the rules expressly provide for sending it back at the town's request. And if the panel wants to reconsider, they're willing to, they're waiting to, they're wanting to, all they have to do is ask. And all the e-court has to do is say, great, one thing less off my plate.
Court, which is a decision's made, the motion to reconsider polls the time to appeal, and the court can reconsider. The same here with the ZBA. I don't know what the purpose of having a different procedure for the ZBA would be, and I think in your brief you argued well that the procedures in the ZBA should be done quickly and give everybody notice of what's happened. But doesn't the filing a motion to reconsider and tolling the appeal period promote judicial economy? Because the ZBA can look at the motion to reconsider and say, oh yeah, they're right, we're going the other way, as opposed to, or we're dismissing this or whatever. You're promoting a process which is file it, wait to hear. If you don't hear, file a notice of appeal. If you file a notice of appeal, it goes to the court. Then if the ZBA decides to look at it, it gets remanded. The decision may be different. Then they have to appeal again to the environmental division, possibly a different decision. How does that promote judicial economy? And I'm sorry I was so wordy.
No, that's okay. You did a good job of making it seem like a very cumbersome process. The answer to that is that these are different proceedings. They're not supposed to be as formal. They're not supposed to be as rule-bound, and they get entirely de novo review at the e-court level. And nothing prevents the municipal panel from simply saying, upon being asked, oh, we'll think about that, sure. And nothing would have prevented someone from doing that earlier in the process to make that request. The sort of law-bound reason for why that wouldn't promote judicial economy is that that's not the rule. That's not the way the rules have been written. I mean, I certainly agree that one could write the rule that way. One could say, let us make the motions to reconsider in an environmental court proceeding function the same way as they do at the civil court level. But that's not what they say right now. And that's not what the rules as the definitions set out by this court say.
Well, when the e-court was created, they adopted many of the civil rules as their rules, and including this one. And this rule says it refers to the Superior Court, filing in the Superior Court. But if the E-Court is adopting rules that consistently refer to the Superior Court, isn't it reasonable to conclude they apply to the tribunal that the appeal is coming from, to the E-Court?
There's nothing in the rules that would tell someone that. I mean, search high and low for some sort of explanation for what that would be, but the rules expressly say that when you use the word court in Rule 5, you're talking about the E-Court. And same thing applies to the rules in the Rule of Appellate Procedure. There's just no indication that those rules are supposed to be interpreted as applying to a municipal panel. You would have to reach down through some sort of interpretive construction process to say it really makes sense to interpret these rules to be.
Well, in fact, in the environmental rules, isn't there a definitional section? And the definitional section actually has specifically different definitions for, I think it's court and also tribunal.
That's Rule 6, yeah.
Yeah, yeah.
And it doesn't include a panel. It's not there. So I think that's the basic response. Sure, it could be a great rule. And presumably, if this court wished to, it could rewrite those rules to do that. But that's not the way they're written right now. If there are no further questions, I'll reserve the rest of my time for
Okay.
rebuttal.
All right, thank you very much. We'll hear from Appellate Counsel. You know, I had a routine when we were all virtual to ask each lawyer to introduce himself. I'd still like you to do it because I think introducing yourself and identifying your client is worthwhile for the record, and I think
Sure.
that helps. So please do that.
So I'm Kevin Brown from Langmark Sperry Wool in Middlebury, and I want to take just a moment to introduce our newest partner, William Basilio, who you'll be seeing a lot of in one way or another because he does a lot of criminal law. So he's
Thanks.
here along with me today. So
Well, welcome. Nice to meet you. Thanks for doing that.
You're welcome. So we're the appellant. I am second counsel on this because original counsel got conflicted out at the appeal time because they took on an associate who had done some work for a neighbor who opposed the project. So it was a late breaking conflict, and a handoff had to be made. So here I am. This is really a simple case, really simple. There's a false dilemma here. Your Honor is correct that this hasn't come before the court before because it's so simple. We're getting hung up, and the brief is hung up on Rule 5, where it mentions only the court can extend it. And yes, tribunals find differently. But the way out of the problem is here, look at Rule 5 when it's talking about extending. It's extending the 30-day appellate period. That's not tolling. That's a different part of Rule 4, Rule 4D, and extending is just like in Superior Court. If a would-be appellant needs additional time to file a notice of appeal, they can come to the court before the appeal period runs, say, I need more time and justify it. Or within 30 days of the running of the appeal period.
Well, they didn't actually ask for more time to appeal.
Exactly. No, that's my point, is that that part of Rule 5, where it talks about the court can extend the time, it's talking about RAP 4D, RAP 4D, not tolling. Tolling happens automatically. So, and it makes perfect sense to me that if you're talking about extending the time, particularly if it's within 30 days of the running of the appellate time period, that requires excusable neglect. Municipal boards aren't equipped to, that's a judicial concept. That's way beyond what municipal boards are typically handling. So the drafters of the rule knew what they were doing when they're talking about that extension power. That's a court function. That's got nothing to do with the tolling provision of Rule 4.
But Mr. Brown,
Yes.
isn't this a Rule 59 motion to alter and amend?
Exactly.
Isn't tolling implicated then?
Yeah, that's what I'm saying, that it's automatically tolled. So the
Oh.
language cited by Attorney Kite in the town that is based on RAP 5's language that says the court can extend, and his point as well. There's no authority here because the ZBA is not the court. The ZBA is a tribunal, so this whole extension period rule doesn't give us any authority for what happened below. The reason why you haven't seen these cases is because tolling happens all the time. It's not extension.
So, Mr. Brown,
Yes,
and I'll ask Mr. Kite this too when he comes back up, but what's the rule that you'd like to see this court apply?
our request is that the filing of the Rule 59 motion, which is what it was automatically tolls the running of the appellate time clock until the decision is made, and then you get the full time for appeal. That should operate just like it operated when you sat in the Superior Court, and you sat in the Superior Court, when you sat in the Superior Court. Well, we sat in the Superior Court.
I sat, but not up
Yeah,
here.
it,
I get reminded of this all the time.
It's just right from the soil.
It's not right.
a distressing amount of time ago, I clerked for Justice Allen, and he was in the same position as you are, and that point came up frequently.
Yeah.
So, I'm asking the court here also to trust the trial court. All this debate about various precedents from 25 years ago in the environmental court is just a distraction. It's this court that can decide and lay down the rule, and I don't think the rule needs to be anything more than perhaps.
Mr. Brown.
Yeah.
Isn't there a point to be made about finality? And isn't, if you look at this body of statutes under chapter, whatever, 120, whatever it is. In
24.
24 in the title. I mean, it appears as though the policymakers, the folks next door, were very interested in making sure that there is finality to the process of permit application at the municipal level. And so that people could understand whether they could move on or not. And how do you respond to that argument? Which is, I think, Mr. Kite's.
That's one of his arguments, yes.
Yeah.
Yes, finality is important, but to a point, and the rule advocated for by the town is actually contrary. It does
Awesome.
more harm than good on finality. So we've already discussed it a little bit, in that the appellate filing of the notice of appeal brings down, it's like the automatic stay in bankruptcy court. The board loses jurisdiction. And so think about practically what happens then in a lot of towns, maybe not South Burlington or whatever. This town meets once a month. So within the 30-day period of appeal period, a motion's going to come in, probably the latter half. Now, if you've got a town that meets twice a month or once a month, and it's a conditional use opinion like this that's being reconsidered, or final subdivision, or variance, or zoning administrator decision appeal, 4464A says 15-day notice has to go out. So for the board to even get together to consider whether it's going to reconsider, you got to get 15-day notice out for 15 days, and it's got to be published. So in my town, I'm attorney for Bristol, and I'm trapped as chair of the ZBA for 17 years. We publish in the Addison Independent. Comes out once a week. Town of Killington, that I represent, also publishes in the Mountain Times. Also comes out once a week. So think about how much time now you're adding just to get public notice out in order to figure out whether you're going to reconsider. What's going to happen then is 30 days are going to run. And under the town's proposed rule, the would-be appellant has no choice but to file, because the board in an awful lot of cases isn't going to be able to get together to make a decision before the 30-day period runs. And then what happens? This is where things get delayed and really costly. Judge Walsh is correct. This is awkward and inefficient, and here's why. The appellate rules, quick and efficient proceeding, if you look at Rule 5, things start to happen. They start to happen right away. The appellant has to send a notice to the zoning administrator clerk, who sends a list of interested persons back. The list of interested persons requires service. The appellant has to serve by certified mail all the interested persons on the list. Then statement of questions has to be filed within 21 days of the filing of the notice of appeal.
But can I just, I understand this process, but another thing that worries me is we're giving the ZBA the ability to, and I'm not suggesting that any of them have any malintent, the ability to just sit on it and for 30 days and hope the defendant or the appellant doesn't appeal during that time. And then according to Judge Wright's decision, they're done. They have no more jurisdiction, the ZBA, to rule on the motion to reconsider after the appeal period has expired. I mean, doesn't that cause problems?
No, because they've already ruled.
But
You know, the would-be appellant is reacting to an actual ruling.
But if I thought under Judge Wright's decision,
Done.
she said that if there was a motion to reconsider and the board didn't address it within the 30-day appeal period, it loses jurisdiction to even rule on that motion to reconsider.
That's not quite what Dunn says, which actually is distinguished pretty well by Judge Walsh in one of his 3 decisions denying this motion. He points out that that decision made up a rule that doesn't exist, just pulled it out of whole cloth. But what Judge Wright said was that you needed to have some notification prior to the running of the 30 days, and then with notice. So because in Dunn, reconsideration happened because the would-be appellant showed up at the meeting and the next meeting, and the board undertook reconsideration without notice to anybody. That was the problem with Dunn. And so it's, I think, limited to its facts. It's also just now followed by the environmental court subsequently.
So Mr. Brown, I want to follow up on what Justice Carroll just asked you, because that's a concern I have. So like you, I served on my local zoning board in Heinsberg for 7 years.
I got $5 a meet. What did you get?
And oftentimes we wouldn't have a meeting. So we met monthly, and there were times there were no applications.
Exactly.
Doesn't the filing of the motion in Superior Court create more consistency throughout the state so that parties know where they should file a motion if they want to seek reconsideration, as opposed to almost like an ad hoc, which each town sometimes will have a meeting, sometimes they won't, and the 30-day period starts to run. I think Mr. Kite pointed that out just in terms of efficiency. So help me understand why your analysis is more efficient.
Well, one, it works very well in Superior Court in all other facets, so there's that. But within the appropriate municipal panel world, some boards do not meet all that regularly. Well, at least once a month. My board meets twice a month, but we don't always have something on the agenda. But when something comes up, what drives the agenda for the next meeting is the notice and publication rule. So that happens regardless. So even a board that meets only once a month or twice a month, maybe doesn't have anything on the agenda for the next meeting, which is a week from now. It doesn't matter because you have to have 2 weeks published notice out there before you get on it as a board. So I don't think it actually adds anything more, but thank you. I want to pay attention, or don't forget, I should say, sorry, that was inappropriate. I didn't mean it that way. We're talking about, Attorney Kite was talking about, well, it's just a de novo appeal, no problem. It's not always a de novo appeal. Some appeals are on the record. And don't lose sight of the fact, please, of what appellants have to do and how much it costs to start the appeal train in environmental court. I've mentioned all, FRAP 5 lays out all the timing provisions. Those things, those duties and costs are going to keep going, have to keep going, while we're waiting for the board to actually be able to get notice out and have a meeting to decide whether it's going to reconsider. And it's even worse in an on the record case. Middlebury's an on-record town. Rule 5 tells us that we have to order the transcript within 14 days of the filing of the notice of appeal. I've got an appeal right now, we just did it, $1,000. So that money's gonna get sunk, and perhaps only to find out a few weeks down the road, well, we do wanna reconsider, now we're sending it back. Maybe the reconsideration goes well and we're all happy, so that money's gone. Or maybe it doesn't go well and now there's, from the appellant's perspective, there's a second appeal or an appeal from another interested person. Now we're gonna do it all over again. We gotta file a new appeal. We've gotta pay the filing fee, which is over $300. And on the record, it's really expensive.
This one's de novo. This case was de novo, correct?
This is de novo. Ferrisburg is de novo, correct? But Rule 5 has time limits for on the record as well that are require expeditious action and carry real expense. Having the hearing I had in Middlebury was little over 2 hours, maybe 2.5 total, $1,000 to have that video transcribed. And so, given what the rest of the Rule 5 requires for things that need to be done in a pretty short time period, those things will have to be done in an awful lot of cases before the DRB gets around to deciding whether or not they're going to reconsider. And if reconsideration is asked for under the town's rule, then all that effort and cost is gone. So my last point is, I think the court ought to trust the trial courts here. Judge Walsh and Judge Dirk have been doing it for a long time, and they know really well what this proposed rule would do, and they consistently rejected it time and time again. They didn't miss the point. Thank you, Your Honor.
Thank you very much. Yeah. How much time does the appellant have?
Appellant has 4 minutes and 44 seconds remaining.
Mr. Kennedy?
Thank you, Your Honor. The rule that the town would request is a ruling that 4A, Rule 4B5, the automatic tolling provisions, are not incorporated into the environmental court rules and are not incorporated applicable to municipal panels. I mean, that's basically the rule. That it doesn't apply to them because it's not the same kind of proceeding. The legislature has set up a different process in connection with municipal panels. The notice meeting requirements that Attorney Brown was just talking about were set up by the legislature as well, who knew full well what they were doing in connection with setting forth how town meetings would work and how select boards and DRBs would work. And they did not provide a provision for reconsideration among panels. That's not in the statute anywhere. The only reason we're talking about it is because it is mentioned in connection with superior court procedure in the rules of appellate procedure.
And Mr. Kite, you just cited 4B5. That can only be relied on by the environmental court if there's lack of notice. Is that right from tolling? Is that how the statute reads? It reads, if a party timely files in the Superior Court, any of the motions referenced below, one of them is a Rule 59 motion to alter or amend a judgment, the full time for appeal begins to run for all parties from the entry of an order disposing of the last remaining motion, but it says only when it's caused by a lack of notice. Is that what you were going back to in the notice, or am I misunderstanding that?
I think you might be misunderstanding. Okay. The position is that Rule 4B doesn't apply to a municipal panel at all because there are no motions to reconsider being filed in any superior court when somebody asks a municipal panel to reconsider. In terms of the finality concerns we're talking about, if you flip this case on its head and you say that it's a neighbor who's challenging a permit that has been granted to a permittee, what you would end up with is a permittee who has bulldozers waiting and ready to go onto the property once the 30th day has passed. They would check the environmental court docket to see if a notice of appeal has been filed and not see one and go ahead and proceed, as they should be able to, in reliance on the fact that there is no notice of appeal filed. They would have no way of knowing that somebody had sent a letter at the 11th hour to the panel asking for a reconsideration And the panel would not have spoken to the parties to tell them, hey, hold your horses. We've got a reconsideration possibility here. You don't need to worry about filing your notice of appeal. Now, that is a judicially crafted rule that has been constructed by the environmental court to deal with this problem of the panel's inherent authority to reconsider its own decisions if it wants to. And in the end, that's sort of the key question that this court's deciding. Who gets to make the decision whether a reconsideration happened? Is it the panel exercising its inherent authority to say, wait, maybe we got it wrong, let's take it back? Or is it the parties before the panel who just have to ask? And then suddenly everything has to stop for the panel to reconsider whether it wants to or not. And it's the town's position that the reasoning in Dunn, it's a good rule, it makes sense. It's an extension outside of the rules. It's not really being imposed based on the rules, it's being imposed based on a need to balance that inherent authority with due process concerns. And it makes sense.
Can I ask a question? Because I'm still wondering about Dunn, which apparently I read wrong, but according to Dunn, if a motion to reconsider is filed and the town doesn't send out notice or do those procedural things within 30 days, they lose jurisdiction, right? The ZBA, isn't that what Dunn said?
Yeah, except it's not a motion to reconsider. People keep calling it that, but it's a reconsideration request to a panel. It's not a motion filed in any court. It's the party saying to the panel, would you reconsider? And what Dunn says is, sure, it's okay for the panel to do that as long as it lets everyone know before the appeal period expires that it's going to do that.
And if they don't let anyone know, then Dunn says they lose jurisdiction.
Right. And the parties should know, I haven't heard back from the panel yet. It's the 30th day. I should file a notice of appeal. That produces clarity for everyone because the parties who didn't learn about the reconsideration request can check the docket and say, oh, there's the notice of appeal file. This matter is not finished. Something still has to happen. But if it's just a unilateral request sent in the mail, nobody knows. And the 30th day comes and goes, and the finality interests that the court has emphasized in this area time and time again are not being respected.
Mr. Chief Justice,
Yeah, yeah.
may I ask one more question?
Yeah.
Thank you, because I did see your light go on. So, Mr. Pike, then the ZBA has to affirmatively open an application before the running of the appeal deadline. Is that right?
It has to let
Under Dunn.
it has to let the parties know we are reconsidering this.
Okay.
That's what it needs to do.
Okay, thank you.
Thank you, Your Honor.
Please call the conclusion of your.
Next hearing for the court is scheduled for 10:45 this morning.